And welcome back, folks. Counselor, you ready to bring in the jury?
No, I do have an issue I need to raise with the court.
Okay, well then have a seat, folks. Thank you. Go ahead, Mr.
Thank you, Your Honor. Your Honor, I make this request reluctantly, but I think it's an important request for the court to consider. I had it brought to my attention by a number of people following the conclusion of the state's comments just before noon in closing argument that Ms. Lister is making very audible comments that are audible to people sitting at counsel's table. I, of course, did not hear them because I'm focused on the jury. Apparently very disparaging comments about me. I don't mind that personally, but I'm very, very concerned about the ability to impact these jurors. I know Ms. O'Connor is about to stand up and give a closing argument. I know Ms. Lister has some fanciful belief that she is a counsel for Michele Anderson, which is not true. And I am concerned that whatever Ms. O'Connor chooses to say will be impacted negatively by Ms. Lister's inability to control herself. She says she has an eruptive disorder. She apparently cannot control it. She has been warned before that there is a history of this. And I'm also concerned that she's having an animated conversation immediately in front of that jury room door where Mr. Eo is now standing. Those doors are not that thick, and I am very concerned about the possibility of misconduct. And in this trial, I'm asking that you have asked Ms. Lister to please leave the court.
Okay. Ms. Sorensen, you want to weigh in on this? I'll be candid with you. I can't hear it from up here. That doesn't mean it's not occurring, but I just frankly can't hear it. So, Mr. Sorensen?
Your Honor, I don't think we really have a position or anything to add to Mr. O'Toole's request.
Okay.
I can, factually speaking, I haven't heard anything. I don't doubt that other people have, but I haven't heard it sitting here.
And I will tell the court, it's not just simply family members of the Mantle or Anderson family. It's people who have no dog in this fight at all. There's an esteemed member of the defense bar, an elderly member of the defense bar who approached me and indicated to me that he had heard comments. There are others in the audience who have also heard comments. I know my co-counsel, I believe, heard that there was definitely comments being made, but she couldn't discern that the others could, though, in the audience. And that is really of concern, not only because it may impact both parties' right to a fair trial, and Ms. O'Connor's closing argument, but the position that Ms. Lister takes right next to the jury room door as the jurors come and go is a real concern that she will mutter something because, as she says, she has an eruptive disorder that apparently she cannot control. And I'm very concerned about both parties' right to a fair trial.
I certainly am too. And Mr. Sorensen, you said you had nothing else to say about this?
Right, we're in a position where we need to defer to the court simply because we don't have enough facts to take a position on the issue.
And to be quite candid about it, my concern is given the current penchant for the Supreme Court to reverse anything, when the court does any action that impedes the public's right to attend proceedings, it makes me a bit timid about what I need to do in order to make an adequate record for that purpose under the Bone Club and the rest of the case law. Frankly, if I had my way about it, we'd be having a hearing and I'd be taking testimony from folks in the gallery that have heard what's been said and so forth, so I can make an adequate record, because I suspect Ms. Lister will tell me that none of this is true.
I'm happy to have one of the persons who is a member of the bar advise the court of what he heard, and he's one of the first persons to advise me immediately after we broke for the lunch hour. That would help the court.
I may not need that. Ms. Lister is standing and apparently wants to say something. So Ms. Lister, go ahead.
Yes, Your Honor. Thank you for your time. And I do not appreciate him slandering me as far as I believe I'm Michele Anderson's defense lawyer. I'm here for protecting appellate issues only, as I've told you. We've established that. His outrageous claims are incorrect. The person who was there, this person was sitting right in front of me and overheard something that I whispered 4 words to somebody else that didn't have any, thing about something about the case. It was maybe a dig on the prosecutor and his behavior of how over the top his performance was. And it wasn't to be heard by somebody else. We've corrected the issue that the prior listening device was very staticky, to where it was turned up so much, and often I have to remove things from my ear so I'm not getting a headache. Some of them are tighter, some are not. I think the problem is solved. If I owe an apology to anybody, I apologize to the family, because that's who I would apologize to. I've done nothing that's not different than anybody whispering in court. That's happened a time. People coming in and out, students and law students. There's nothing that has given any information, indication, bias of anything in the trial. And I think that's where your line is, that what you're supposed to protect. You know, as we know, there's a right to access to courts with TV and her not seeing her, you know, discovery, lots of access to court things. And I think you are correct in reserving the fact of throwing me out at the inclination that one person stood up after you were in chambers and said or repeated what he thought he said or had heard from him out of my mouth, that everyone else heard, so then it multiplied from there. But other than that, one person that I know of heard it, because these benches are too close in proximity. That's why everybody squishes in between, but it was meant for the person next to me. And I'm not at the jury door, and this prosecuting person is always standing guard at the jury door. There's media between me. There's the static of media possibly as well. So I think the issue is resolved, and I appreciate you reserving that, because I do believe it would be an appellate issue, as we've already stated and put on the record. Just, I would like no more slanders from Mr. O'Toole, and the family deserves to finish the trial. Michelle deserves to finish the trial. And I think this is part of the circus making that Mr. O'Toole is involved with Mr. Sanders as well, from what I've seen posted. Thank you, Your Honor.
I will advise the court that I've been advised by Detective Tompkins that Ms. Lister's comments were picked up and recorded by the media, the TV camera. So,
And do we have an indication of how many words, how many sentences, duration of time, anything like that?
I do not. And as the court can imagine, I know the court is as concerned, if not more so than anybody else in this room, with respect to being able to finish this trial. You know, I totally understand, and I don't mean to make the court's life more difficult. I really don't. But
No, you're not making my life difficult. Frankly, the appellate courts have made my life difficult, because they turn this into field day for anybody who wants to come and go. If I had my way, people wouldn't be treating this like they were at the movies and having little conversations in the background. They'd come in here and they'd sit down and they'd shut up. But that's not what happens nowadays. And it makes it very difficult to control. People come and go. I was given jury instructions earlier this morning, and some gentleman was climbing over people in the back row loud enough to cause me to interrupt giving the instructions. It's making it impossible to do this job the way I think we ought to do it. And right now, my best solution to the problem, if I'm going to address it, would be to take testimony, make a sufficient record. Then I think what I would hear from Ms. Lister is she needs an ADA accommodation, which I would then have to go through that entire set of protocols. And then I'd probably have to find her an alternative viewing space and get a Skype set up so that she can watch it remotely. Otherwise, I run afoul of ADA accommodations. It gets worse and worse the further you go down this path. And I hope everybody in this courtroom understands that. And in the meantime, we're trying to try in a fair, efficient, appellately correct way a 6-count homicide case while dealing with all of this other static noise.
Your Honor, I have a solution. I will step outside and use my hearing device if that will suffice for you in the event that I have done nothing wrong. And that's, I'm not a person to drag out the appellate ADA. I asked for full accommodations and you gave me half, as the record you have shown. I would gladly step outside. I'm not going to take your time. And again, I reiterate this to the media circus of him being blaspheming. He's more worried about his character and why he couldn't get Paul Sanders to have that initial feed when the media wasn't here. And that's what that is stemming from. So I will gladly step outside if it appeases the court. You will not have any more problems that are brought up from somebody who is sitting right next to me, not everybody else, as it's been sputtered over the break. And I do not ever talk to jurors. I wouldn't do something like that until conviction or appellate process or whatever happens after that. I have no intentions of that at this time.
Okay,
so thank you.
Ms. Lister, can you hear hear?
I
from
should
the-
be able
from
to.
the
I've got
hallway?
I have a new device, and that's one of the problems that it was. I've solved it with the help of Kenya. I actually went and solved it myself with court administration and interpreter services. We're all fine. Thank you, Your Honor.
Okay, so Ms. Lister, if you, I want to make it clear for the record, you're voluntarily making this action to move into the hallway to avoid further complications.
For closing
Correct
arguments, if there's anything on the record as far as addressing something after that, when the media is out there and gone or on a break, then I may re-enter the courtroom at my own leisure, if that's okay with the court as well, for anything that goes on as far as motions where the jury's not present.
I just want to get through closing arguments this afternoon.
No problem.
The jury needs to get this case for deliberation.
You and I are on the same page, thank you.
Okay.
Judge,
Now,
I want to apologize for this morning, since you brought...
I didn't even know who it was, sir. Was it you?
Yeah, I
Okay.
apologize.
I appreciate that. I appreciate your apology, sir, but it's the problem that's inherent with people coming and going. If I had my way, we'd start the proceeding, close the door, and if anybody wasn't here yet, too bad. And if everybody comes in, they stay until we're done. But I don't have that kind of power and control anymore, thanks to my friends on the appellate courts who don't have these problems. So with that, I think we're ready now for the jury to come in. Yes, usual. Hey, Ms. O'Connor, you're good to go? Yes?
I'm sorry.
Okay. And I'll let the jury know about the typo on page 28 of the instructions.
Please rise for the jury.